No public testimony under oath. Instead, a written non-prosecution agreement was signed between the United States Attorney's Office for the Southern District of Florida and Jeffrey Epstein's defense attorneys. That document, later unsealed and now part of the public federal record, stated that the United States would not pursue federal prosecution if specific conditions were met. According to FBI investigative records and filings later released in court, federal authorities had examined potential charges involving the sexual exploitation of minors under federal statutes carrying significant penalties. The agreement was executed in September 2007. Under its terms, in exchange, federal prosecutors agreed not to bring federal criminal charges. The agreement also included language extending protection to potential co-conspirators. That clause appears in the publicly released text of the agreement. Epstein later pleaded guilty in state court and served 18 months in county jail. No federal prosecution followed. To understand how this happened, it helps to understand prosecutorial discretion. The Department of Justice's own Justice Manual explains that federal prosecutors evaluate admissible evidence, likelihood of conviction, and federal interest when deciding whether to bring charges. Non-prosecution agreements are recognized tools within that framework. In corporate and financial enforcement cases, they are frequently used to resolve investigations without trial. They define exposure. They manage risk. They bring certainty to uncertainty. In 2004, Congress enacted the Crime Victims' Rights Act, giving victims the right to be informed and to confer with government attorneys. Years after the agreement was signed, litigation challenged whether victims were properly notified before the agreement was finalized. In 2019, U.S. District Judge Kenneth Mara ruled that federal prosecutors violated the Crime Victims' Rights Act by failing to notify victims prior to executing the non-prosecution agreement. That ruling is documented in federal court opinions. However, the court did not invalidate the agreement. It remained in effect. Then in July 2019, more than a decade later, federal prosecutors in the Southern District of New York unsealed a new indictment charging Epstein with sex trafficking of minors and conspiracy. This was a different federal district. A new case. Court proceedings began. On August 10, 2019, Epstein died in federal custody. The death was ruled a suicide by the New York City medical examiner. Following his death, the criminal case was dismissed. No federal trial occurred. The public record consists of indictments, plea agreements, court rulings, and official filings, not sworn courtroom testimony. From a systems perspective, and here at the Human Timeline TV, we look at systems. Negotiated agreements are tools used across criminal and financial enforcement. They are not rare. They are instruments of discretion. The Department of Justice publicly describes such agreements as mechanisms to achieve enforcement objectives while conserving resources and managing litigation risk. In finance, uncertainty moves markets. In law, discretion shapes outcomes. The documented sequence shows a federal investigation, a non-prosecution agreement signed in 2007, victims not notified prior to execution, a later federal ruling acknowledging procedural violations, the agreement remaining intact, and a separate 2019 indictment ending without trial due to death. Those are the facts as reflected in official government records. History doesn't just record events, it records structures. And when you look at enforcement through a historian's lens, patterns emerge in how discretion, negotiation, and legal architecture operate. If you want the next layer, the financial architecture surrounding wealth structures, charitable entities, and asset networks documented in IRS filings and federal records, that's where we go next. This is the Human Timeline TV.